Hi, everyone. Good morning, good noon, good afternoon, good evening, wherever you are. I hope that all of you are doing well and fine. And I would like to welcome you to this presentation on the generation of rights. This is part of the course in human rights and gender relations. And this is your professor, Dr. Herbert B. Rosana from the Department of Peace Studies of the College of Social Sciences and Philosophy, Bicol University, Legazpi City, Albay, Philippines. So get ready because we will be going on board in our discussion. So you can have your notes, and as you listen, you can take note of some of the important insights that I will be presenting to you in this presentation. The concept of the three generation of human rights was first proposed by the Czech jurist Karel Vasak in 1979 at the International Institute of Human Rights in Strasbourg in Germany. The theory divides human rights into three categories of generations based on the time in which they were recognized and the nature of the rights themselves. This categorization or description of human rights is important for us in the sense that it helps us gain the idea or the conception on how these rights were recognized by the United Nations and the international community, and also the evolution by which the international community recognize and gain an understanding of human rights. However, we should also remember that it doesn't mean that these rights were non-existent as previous. In fact, these rights has always been part of human history, and yet it took time for human beings or for the international community to recognize these rights. And in fact, it took the international community to experience the horrors of World War One and World War Two in order to push themselves to take into consideration seriously the meaning of human rights. So therefore, for the purpose of understanding and for also for academic discussion, human rights have been designated into the generation of rights. So these rights are divided into three parts. You have the first, the second, and the third. So we will discuss in the following slides the different generations of rights and their meaning. So hold on, and as we proceed to the next slide. Before we proceed with our discussion on the three generations of human rights, it's important that as a matter of helping you unlock your difficulties, let us first define three important terms commonly used in diplomacy and in the United Nations. These terms are treaties, protocols, and conventions. Although these terms have been part of the world since the beginning of civilization, they have become more common in today's world. The terms are often confusing as they are used in similar settings, however, they differ from each other. So we should not confuse one to the other because they have differences in meaning and they have differences in gradations and effectiveness. So if you are engaged in diplomacy, you will always encounter these terms. For example, when we think of the dispute in the South China Sea, then we are confronted with the United Nations Convention on the Law of the Sea. So therefore, we should be able to understand that the UNCLOS is a convention. So it's different from a treaty and from a protocol, but somehow it is also the same as a treaty because it involves agreement and compliance among those who acceded to the document. So, what are human rights instruments? And perhaps you will be hearing these terms often. So, in order for you not to be misled or maybe you will not be confused about the terminologies, we will first define what human rights instruments. So human rights instruments refer to the legal documents that provide the foundational framework for international human rights. The Universal Declaration of Human Rights, or the UDHR, and the nine core rights treaties are the primary instruments of the international human rights framework. So when we say human rights instrument, these are the collections of treaties, conventions, and protocols that have become the basis for the operationalization of these legal frameworks in the relationship among the international community. So what are these nine core treaties? So when we say core, meaning to say it is the basis, the origin of all forms of legal instruments. So number one, we have the International Covenant on Civil and Political Rights. And second, we have the International Covenant on Economic, Social, and Cultural Rights. Both of these were uh, promulgated in 1966. And third, we have the Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment or Punishment. So this is very important because this is the treaty that prohibits the use of torture, especially in interrogation, and also the abolition of the death penalty. So most of the members of the UN or the international community, there is a strong pressure to abandon death penalty and to also abandon the cruel and degrading punishment because it all redounds to the idea, to the concept that each human being possess certain degree of dignity that must be respected. And four, we have the Convention on the Rights of the Child. So in this convention, the right of the child is recognized as one of the most vulnerable and yet very important element of society or community. Then we have the International Convention on the Elimination of All Forms of Racial Discrimination. This is an age-old problem which this kind of treaties is seeking to correct. Then number six, we have the Convention on the Elimination of All Forms of Discrimination against Women. So because historically, women has been relegated into the background because of the prevailing philosophy of patriarchy, the social practice of patriarchy, which the feminist movement tries to change. Okay, so seven, we have the International Covenant for the Protection of All Persons from Enforced Disappearance. Okay, so eight, we have the International Convention on the Protection of the Rights of All Migrant Workers and Members of their Family. This is also very significant because this instrument aims to provide protection for migrant workers and also to recognize their inherent rights as persons and as workers entitled to benefits and privileges. Because our world is now globalizing, and this process of globalizing and the opening up of borders also create a peculiar situation when people from other countries would migrate in order to find work. Then nine, of course, is the Convention on the Rights of Persons with Disabilities. So a recognition of those people who are with special needs, particularly those who are impaired in their movement and whatever kind of impairment that they have. And this is now being recognized and respected. So in the last slide, we mentioned about treaties, the nine core treaties. So let us define what treaties are. So a treaty refers to an international agreement between two parties, members, or even nations. When we talk about it on a global scale, the term refers to an agreement between two or many countries. A treaty is an instrument to created by international law, whether embodied in a single instrument or in two or more related instruments, and whether it is a particular designation. Typical examples of international instrument designed as treaties are peace treaties, border treaties, delimitation treaties, extradition treaties, and treaties of friendship, commerce, and cooperation. So when we say that mention about treaties, there are treaties can be of two kinds. There are what we call bilateral treaties or multilateral treaties. So when we say bilateral treaties, these are treaties or agreement between two independent states. Then when we say multilateral treaties, it refers to two or more or a group of countries agreeing to abide by certain conditionalities. So those are the two types of treaties. And sometimes a treaty can be a single instrument, or it can be a two instrument or more. Like for example, when a treaty has a supplementary provisions that are acceded to by some of the members of the original treaty. So sometimes a treaty can also have exceptions. For example, when a country accedes to a treaty but have some reservations on some aspects of the treaty, some treaties allow such kind of reservation. So when we say reservation, meaning to say um, the country is deferring its ability to comply, or deferring its compliance to a particular provisions of a treaty, because maybe perhaps it thinks that they will not be able to comply with the requirements of that particular treaty. So, and treaty also has the force of an international law. Although one of the peculiarities of international law, because there is no, although there are some enforcement mechanism, but unlike an singular state where there is the police power, an international law does not have that kind of police power unless some members of the international community or some members or signatories of the treaty decides to implement the the ruling or implement the provisions of international law. And sometimes the implementation or enforcement of the law is collective, and it can take many forms, like for example boycott or maybe sanctions given to a particular country. These are examples of how international law or treaties are enforced. That's why when a country accedes to a treaty, it should understand that there is a compliance expected of the member countries, and they are expected to comply, and they are expected to have the ability to comply with the requirements of the treaty. And some treaties are quite elaborate. They have some reporting mechanisms, and sometimes compliance to the treaty can also be can also be weaponized by some countries, for example, and it can also be the basis for foreign aid, or in dealing or setting up the conditionalities for relations between two countries. Now, a protocol. What is a protocol? A protocol is a document that is legally binding and allows alterations and amendments to the main treaty. It is an instrument subsidiary to a treaty and drawn up by the same parties. So in a sense, this is like sort of a supplementary to the original treaty. So for example, the civil and political rights, there is an additional protocol to that. And because sometimes there are certain needs that have been overlooked by the mother treaty, or perhaps there are some complicated um, aspects of the original treaty that perhaps some of the members would like to make it more specific and more targeted. That's why they always agree to come up with protocol. On the other hand, a convention is something that happens prior to a treaty being formed. It can also mean a treaty among a number of countries. Then the objective is that multiple countries must come together, meet and discuss an issue at hand before signing a treaty or legally binding contract. So in other words, a convention is also a document, an agreement, but it is something that is done prior to a the signing of a final or legally binding contract. You know, in international law, although we say that the enforcement of a treaty or convention or protocol is difficult because there is no implementing body, there is no specific body to enforce the law, and yet um, compliance is still important because once you become a member of the community of nations, it is always expected that you're going to comply with the requirements or your obligation to the community of nations. Because if you fail to comply with these requirements, it can also have some repercussions to you, especially in dealing with other countries. So you will become a sort of a pariah to the international community, and your international relations or diplomatic relations will suffer. Not only the diplomatic and the political aspects of it, but you might also suffer from the economic aspects of it. Because, you know, international relations is intricate, multi-layered, and multi-dimensional. It involves politics, it involves economics, and it involves um, many other things that are important for the well-being of a country. And especially that if you are a country and you are, say, concerned with your own interest or promoting or safeguarding your interest, then you really have to be able to comply to the requirements of the international community. And you know, the enforcement of of the international law or treaty can become not only in the forms of pressure, not only in the means of sanctions, but there can also be military actions taken. So there are many avenues by which member countries try to enforce the treaty, and especially if the non-compliance to the treaty affects the well-being and interest of another country, especially the powerful countries. So the first generation of human rights, also known as the blue rights, are civil and political in nature and deal with liberty and participation in political life. These rights include the right to life, freedom of speech, property rights, and voting rights, among others. And the three instruments associated with the first generation of rights are uh, first, you have the Universal Declaration of Human Rights, UDHR. Then second, you have the International Covenant on Civil and Political Rights. And third, you have the European Convention on Human Rights. So the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the European Convention on Human Rights are important legal instruments that protect the civil and political rights of individuals. The UDHR was the first step towards universal human rights and has inspired more than 80 international treaties, declarations, conventions, bills, and constitutional provisions. So the ICCPR is a legally binding treaty that obligates its signatories to respect and protect the civil and political rights of individuals, including the right to life, freedom of speech, and freedom of religion. So the ECHR, or the European Convention on Human Rights, is a regional treaty that protects the human rights of individuals in Europe, including the right to a fair trial and the right to freedom of expression. However, there are controversies associated with these legal instruments. Some critics argue that the UDHR is not legally binding and lacks enforcement mechanism, which make it difficult to hold governments accountable for human rights violations. Others argue that the ICCPR and the ECHR are too focused on individual rights and do not adequately address economic, social, and cultural rights. There are also concerns that the ICCPR and ECHR have been used to justify military interventions and other forms of interventions in the internal affairs of sovereign states. Despite these controversies, the UDHR, ICCPR, and ECHR remain important legal instruments that protect civil and political rights of individuals. They have inspired a rich body of legally binding international human rights treaties and continue to be an inspiration to us all in our efforts towards achieving universal enjoyment of human rights. The second generation of human rights, also known as economic, social, and cultural rights, includes the right to work, the right to education, the right to health care, the right to social security, and the right to an adequate standard of living. These rights are based on the principles of social justice and public obligation and tend to be positive rights, which place a claim on the state and a duty to oblige for action. The second generation of rights emerged in response to the predations of unregulated capitalism from the mid-19th century and the need to protect the most vulnerable members of society. They are often associated with the welfare state and the idea that governments have a responsibility to provide social and economic protections for their citizens. There are controversies associated with the legal instrument uh, that are associated with the second generation of human rights. Some critics argue that these rights are too focused on individual rights and do not adequately address economic, social, and cultural rights. Others argue that the second generation of rights is too focused on the welfare state and that the governments should not be responsible for providing social and economic protections for their citizens. There are also concerns that the second generation of rights have been used to justify military interventions and other forms of intervention in the internal affairs of sovereign states. So perhaps you can make some research, perhaps online or perhaps in your library, about military interventions and how these interventions use human rights as a justification for their illegal actions. Okay, so on the right side of the presentation, you can see the list of the three um, international legal instruments associated with the second generation of rights. So you have the International Covenant on Economic, Social, and Cultural Rights, and then you also have the Convention on the Rights of the Child and the Conventions on the Elimination of All Forms of Discrimination Against Women. You can access all these legal instruments from the internet. You can read some of them, and you can also try to search some commentaries about these legal instruments. So we come now to the third generation of human rights. The third generation of human rights, also known as solidarity rights, are rights that go beyond the mere civil and social as expressed in many progressive documents of international law, including the 1972 Stockholm Declaration of the United Nations Conference on Human Environment, the 1992 Rio Declaration on Environment and Development, and other pieces of generally accepted international law. These rights are concerned with social groups and society as a whole rather than an individual. They are therefore seen as collective rights and are based on the principle of solidarity and cooperation. So the underlying theme of the third generation rights is fraternity, which emphasizes the importance of social harmony and the common good. Examples of third generation rights include the right to a healthy environment, the right to peace, the right to development, and the right to communication, and the right to humanitarian assistance. So the legal instruments associated with the third generation of human rights are not well defined as those associated with the first and second generations of rights. However, some of the legal instruments that have been developed to protect third generation rights include the Stockholm Declaration on Human Rights, no, the Stockholm Declaration on the Human Environment, and the Rio Declaration on Environment and Development, and the United Nations Framework Convention on Climate Change. Now, there are controversies associated with the legal instruments as far as the second generation of human rights is concerned. Some critics argue that these rights are too focused on individual rights and do not adequately address the economic, the social, and cultural rights. Others argue also that the second generation or the third generation of rights are not as well defined as those associated with the first and second generation of human rights. However, some of the legal instruments that have been developed to protect third generation rights include the Stockholm Declaration on the Human Environment and the Rio Declaration on Environment and Development, and also the United Nations Framework Convention on Climate Change. The notion of three generations of human rights has endured for almost 40 years, but it has no solid historical or analytic basis, and it obscures rather than clarifies the relationship between rights. So critics argue that the theory promotes the third generation collective rights agenda pushed by a number of UN member states and to little actual benefit and obscuring existing human rights legal obligations. And finally, we come to the conclusion of our discussion, and we close it with the last question, which is there a fourth generation of rights? The fourth generation of human rights is emerging, which would include rights that cannot be included in the third generation. And these are future claims of first and second generation rights and new rights, especially in relation to technological development and information and communication technologies and the cyberspace. So these are the fields, emerging fields in human rights, and we hope that in the future, with the further deliberations and dialogues among peoples, among stakeholders, that um, a fourth generation of right can be articulated. So thank you very much for listening, and I hope to see you again next time around.